My name is Jeff Morgan. I am from Dallas, Texas. I'm going to speak on the issue of no-fault divorce and how no-fault divorce, granting no-fault divorce, is religious viewpoint discrimination, and it is also a violation of the Establishment Clause. Now, viewpoint discrimination is the term that the Supreme Court has used to identify any type of a government law, rule, decision that favors or disfavors one or more opinions on a particular controversy. Viewpoint discrimination is a form of content discrimination, particularly disfavored by the court. So the courts are not supposed to make judgments based on somebody's viewpoints. The courts are supposed to make judgments based on an action or an infraction of some type of a law that's in place. When the government engages in content discrimination, it is restricting speech on a given subject matter. When it engages in viewpoint discrimination, it is singling out a particular opinion or perspective on that subject matter for treatment, unlike that given to other viewpoints. And this will be very crucial as I talk a little bit more about unilateral no-fault divorce. When the government targets not subject matter but particular views taken by speakers on a subject, the violation of the First Amendment is all the more blatant. Viewpoint discrimination is thus an egregious form of content discrimination. The government must abstain from regulating speech when the specific motivating ideology or the opinion or perspective of the speaker is the rationale for the restriction. Now let's take this a little bit further and look at religious viewpoint discrimination. Although viewpoint discrimination often involves political speech, it can arise also when the government treats religious speakers less favorably than non-religious speakers. The Supreme Court made this abundantly clear in two decisions in the mid-1990s. Lamb's Chapel versus Center Moriches Union Free School District in 1993, and also in Rosenberger. In Lamb's Chapel, a public school district opened its facilities for after-hour use by community groups for a broad range of social, civic, and recreational purposes. However, it denied access to a church group that sought to show a film series addressing family values and child rearing from a, quote, Christian perspective. The court held that the school district had violated the First Amendment by engaging in viewpoint discrimination. It discriminates on the basis of viewpoint to permit school property to be used for the presentation of all views about family issues and child rearing except those dealing with the subject matter from a religious viewpoint. So when the school district tried to regulate out of the school a Christian perspective on family values and child rearing, that was considered discrimination. Discrimination against the group that was trying to bring forth its religious viewpoint on a matter, an important matter such as family values and child rearing. In Rosenberger, the court held that a student religious journal at the University of Virginia was entitled by the same subsidy from student activity funds received by secular journals. In other words, if there was a fund set up for people to put out a journal, you could not discriminate against a journal because it held a particular religious doctrine. The court concluded that the university's policy of withholding the subsidy from student religious journals was a form of viewpoint discrimination. Viewpoint discrimination based on religion. The university does not exclude religion as a subject matter, but selects for disfavored treatment those student journalistic efforts with religious editorial viewpoints. Religion may be a vast area of inquiry, but it also provides, as it did here, a specific premise, a perspective, a standpoint from which a variety of subjects may be discussed and considered. The prohibited perspective, not the subject matter, resulted in the university's denial of the subsidy. And the court ruled that that was not permitted. That was viewpoint discrimination. Viewpoint discrimination based on religion. Viewpoint discrimination is thus an egregious form of content discrimination. When you are censoring somebody or discriminating against somebody based on his or her religious viewpoints, you are actually discriminating against his or her right to free speech, against the content of the speech. The government must abstain from regulating speech when the specific motivating ideology or the opinion or perspective of the speaker is the rationale for the perspective. And I would add here too that the courts must also not take action against a person because of his or her religious viewpoint. And this will come up as I discuss no-fault divorce in a few moments. Policy prohibits discrimination. Our law prohibits discrimination on the basis of race, sex, religion, age, and even sexual preference. If you are not ruling against a person on the basis of conduct or evidence, on what basis are you making a ruling against a person? If you are ruling against a person based on his or her viewpoint, you have viewpoint discrimination. And if you are making a judgment or a ruling against him or her on the basis of his or her religious viewpoint, you are engaging in religious viewpoint discrimination, forbidden by law. And this goes to judges, this goes to courts, this goes to government entities, this goes to school districts, this applies to all sorts of entities. Religious viewpoint discrimination is not permitted. It is prohibited by law. Going to the issue of no-fault divorce. In no-fault divorce, the judge is not asked to rule on some type of a conduct matter. There's no fault. If there's no fault, what is the judge ruling on? The judge is making a ruling on one person's viewpoint. So if you have a petitioner saying, my viewpoint is that the marriage is irretrievably broken, but you have a defendant saying, but I don't believe it's irretrievably broken, and the judge always, without exception, 100% of the time, agrees with the person who says, well, he says or she says the marriage is irretrievably broken, excuse me, that is viewpoint discrimination. And if the respondent says, we may be having some hard time, but based on my religious commitment, my religious belief, I do not believe in divorce. I do not believe in unilateral no-fault divorce. In fact, I am a Christian, and according to the words of Jesus, unilateral no-fault divorce is not permitted. And if I'm a Catholic, I would say the Catholic Church believes in the indissolubility of marriage. We have had a Catholic marriage. We've had a Catholic wedding. We've gone through all the Catholic rituals. And to rule against me would be to say you are ruling against me on the basis of my religious viewpoint. There is no action. There is nothing that I have done or somebody else has done that has brought forth this lawsuit against the person. The judge has no standard by which to make a ruling for one person or against another person except on the basis of viewpoint. And in a situation where the respondent holds the religious viewpoint that divorce is prohibited by his or her religion, you now have religious viewpoint discrimination. Going back to the First Amendment, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. So in any type of an instance in where a judge is issuing the dissolution of a marriage based on the viewpoint of one person against the viewpoint of a person who does not agree with the assessment that the marriage is irretrievably broken, that judge is engaged in viewpoint discrimination, and in the case of a person of faith, he or she is involved in a case of religious viewpoint discrimination. In other words, what this judge is doing, he or she is establishing a religion that says divorce is okay. It's establishing an ideology that says, well, if one person says the marriage is irretrievably broken, on that basis, on that viewpoint, I will grant a divorce. That is forbidden by law. That is also the establishment of a particular ideology, or in a case where you have two religious people and say one is a backslider, one is disobeying God. Two people get married in a Christian church. They take their vows to God. They make their vows in front of each other. They have said before God, our marriage is till death do us part. And one person later on says, well, you know what? There's really no fault here, but I just want to have a different type of life. I want to be a single person now. I want to abandon my family. And furthermore, I want to take the kids with me. I want to abandon my spouse. I want to take the kids. What did your husband or wife do? Well, not really anything, but I am saying it is insupportable. Well, I'm sorry, but that is your viewpoint. If your husband or wife says it is not insupportable, the judge has nothing to make a ruling on. He or she is only making a ruling on the basis of viewpoint, or religious viewpoint, or anti-religious viewpoint. The judge is engaged in religious viewpoint discrimination. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. In my religion, if I am married, the free exercise of my religion is that I remain married. So if a judge dissolves my marriage with no evidence, no reason, no standard by which the marriage should be dissolved, but basically on the viewpoint of my spouse, the judge is prohibiting the free exercise of my religion. The judge is engaged in religious viewpoint discrimination, and the judge is also prohibiting the free exercise of my religion. The judge is favoring my spouse's irreligion or disobedience to the same religion if we got married in the same church and have the same religious teaching. And he is ruling against my desire to uphold and to keep and to exercise my free exercise of my religion. The judge may be ordering me to do something against my conscience. If I am a Christian person who believes that divorce is against the will of God and to do something against the will of God is sin, the judge is ordering me, forcing me to sin. This also is religious viewpoint discrimination. It is also compelling a person to agree with and to sign something that he or she does not believe in. This is where judicial injustice takes place. So a little over a week ago, I was at a forum in Rockwall, Texas, the Rockwall County Men's Republican breakfast, and Judge Brett Hall, by the way, was the judge who ordered the dissolution of my marriage, and Judge Brett Hall said he would not relitigate the case. Well, the reality was Judge Brett Hall never litigated the case to begin with. There was absolutely no evidence found. There were no grounds for the action. The judge just simply discriminated and took the viewpoint of my wife versus me. Even though my wife knew that what she was doing was wrong, even though everyone in her family disagreed with her, even though all of our friends disagreed with her, the judge simply took the viewpoint of my wife, who at that point in time knew that she was disobeying God. Furthermore, my wife also wrote to me, and even after she claimed irretrievability and irreconcilable differences, she stated she was holding out hope to the very end. So this judge who exercised religious viewpoint discrimination against me also caused the needless destruction of a marriage, Judge Brett Hall, and there was no litigation. Judge Hall stated that he was not going to relitigate a case that he did not remember. Now, Judge Hall was it was a device that he was using to draw attention away from the fact that no litigation ever took place to begin with. To relitigate a case means that the case had to be litigated to begin with. Judge Hall never litigated the case. Judge Hall lied to the people, and he knows it. I would like to see if Judge Hall has ever once in his tenure as a judge denied a divorce. Judge Hall, please feel free to contact me. I know you've been a judge for a while. And in fact, let's take this a little bit more. Could you give me, like, say, 3 to 5 examples in which you have denied a divorce, a no-fault divorce? Or is it true, Judge Hall, that in every single case that a no-fault divorce comes before you, you order the dissolution of a marriage? In my instance, it was less than 5 minutes. My ex-wife answered a certain number of questions, and I answered a few questions based on my name, my residence, where I lived, and you knew for a fact, Judge Hall, because you saw my signature that I disagreed with it, you knew that I did not agree with it, and yet you ruled against me. Judge Hall, you were engaged in viewpoint discrimination. You ruled for the viewpoint of my wife, even though her entire family was against it, even though all of our friends were against it, even though the entire church was against it, even though my ex-wife was not even sure. You declared the dissolution of my marriage. There was no litigation. And your friend, Charles Schurenberg, the lawyer who told me when I went to appear before him, there's no need for a divorce. He said, you're getting a divorce and there's nothing you can do about it. Because Judge Hall, in your court, if somebody goes before you, there is nothing that a respondent can do to a petition for divorce. You are engaged in viewpoint discrimination. And in my case, you were engaged in religious viewpoint discrimination. My ex-wife knew that what she was doing was wrong. My ex-wife knew and had confusion at the time, was not even sure that she was doing the right thing. And Judge Hall, you made a decision to destroy a family based on a viewpoint that you favored. And it was not just religious viewpoint discrimination. You chose a viewpoint that said a person who abandons his or her religious faith actually gets preference over the person who is keeping his or her religious faith. Judge Hall, Perhaps you don't know this, but my ex-wife and I met at Bible college. We were missionaries together. Her father, a so-called minister, who I found out later on I don't think really was a minister, but a so-called minister who married us with the intention that we were going to be married for life. Our vows that we took in front of people were until death do us part. My wife knew that what she was doing was wrong, but Judge Hall, you gave her umbrage in your court when you ruled based on a viewpoint. You chose to favor a viewpoint that was anti-religious, that was against the teaching of his or her religious doctrine, and you granted a divorce. The First Amendment clause once again prohibits the government, and also Judge Hall, prohibits the government from making any law respecting an establishment of religion. The clause not only forbids the government from establishing an official religion, but also prohibits the government actions that unduly favor one religion over another. Judge Hall, I don't know, I'm assuming that you are a Christian. I knew your father when he was alive. We had lunch a few times. I don't think Representative Ralph Hall would have taken the same position that you, Judge Brett Hall, did, favoring a backslider in heart, a person who was running away from her religion because it was convenient at the time. And once again, Judge Hall, she was not even sure she was doing the right thing. In fact, she said many times that she wasn't. She was holding out hope to the very end. But her attorney, Charles Schurenberg, and by the way, that attorney, Judge Hall, the guy that came in and said, Judge, and you said, hi, Charlie. When a judge says to a counsel for the other person, hi, Charlie, you want to go out for lunch afterwards? Hi, Charlie, you want to get together for beer and steak at my house later on? Hi, Charlie, you want to take a boat ride with me? Hi, Charlie. That was completely unprofessional of you, Judge Hall. And once again, perhaps that's why Charlie could say, you're getting a divorce and there's nothing you could do about it. Because perhaps you and Charlie Schurenberg were just so good buddies that, hey, I'm going to appear before Judge Hall. Judge Hall and I are really tight. He's going to do whatever I want him to do. Perhaps, Judge Hall, you could explain this, and you could explain your perspective and your decision to the Rockwall County Republican Men's Breakfast. Because what you did, you ruled in favor of one viewpoint over another. I will continue on with the subject in another video, but I will actually illustrate this more specifically from my own case. Thank you.